All right, let's finish freedom of religion by discussing the free exercise clause. Free exercise clause is not a prohibition. It does not tell the government what they can't do. What it does is tells people what they can do. So government, and that is practice their religion without being interfered with. So, I guess technically the government is prohibited from interfering. But just like we established way back in 1879, there are instances when the government can interfere. It, like any other part of the Constitution or of the Bill of Rights, is not absolute. So, bottom line, the government has the ability to jump in and say, yeah, that practice, even though it is recognized by your religion, is not valid and cannot be allowed and even can be illegal if it causes harm. So here are some examples. This is Alfred Smith. Mr. Smith was fired from his job because when he was drug tested, he tested positive for a hallucinogen, specifically peyote. And Mr. Smith said, wait a minute, wait. I use peyote as part of my religious observance. It is used in religious ceremonies for clarity and to help me commune with the gods. And so, but he was fired. He was fired, and they upheld his firing, saying that we cannot allow a hallucinogen to be in your system in certain instances because people might be hurt. So this was one of the reasons that it was upheld. So anytime there is a challenge to a law on the basis that it is criminalizing my religious practice, the government, we say the state, but when we say state, we mean any level of government. That could be local, that could be state, that could be federal, has to provide a compelling reason, keyword, compelling reason to limit the exercise of religion. In this instance, it was the safety of the people that were taking advantage of, or that were enjoying the services of Mr. Smith. We're going to put a pin in that. Let's talk about polygamy. And I don't know where I found this picture. I don't know. But there are polygamy. In Texas, we call it bigamy. But having more than one spouse or purporting to have more than one spouse is not legal. There are many religions even today, not many, there are some religions even today that practice polygamy. And it is illegal. Now, do we have a tolerance for some activities, even though it's illegal? A lot of times we're talking misdemeanors, we're talking fines. A lot of times the law enforcement looks the other way unless something else is going on. Even with our big case in Texas with Warren Jeffs, who had moved to Texas, and he was a member of the Fundamentalist Church of Jesus Christ of Latter-day Saints. He had several wives, but he didn't get convicted for bigamy. He got convicted because one of his wives was underage, and so he had multiple sexual assault on a minor charges. And the reason that they knew that he was sexually involved with a wife was because one was 12 years old and she got pregnant, so couldn't deny it. And they ended up pulling out um, dozens of women that were part of Warren Jeffs' family, that were wives or that were children of Warren Jeffs. But even in that instance, even though it's on the books, even though it's against the law, there are times when we look the other way. They may not still be on, but there have been reality shows that show sister wives. Um, and I used to watch on HBO, there was a show called Big Love, and it was a modern day group of fundamentalists who were polygamists, and people didn't know, people were trying to figure it out, and it was um it was tolerated in to a certain extent. Another example, snake handling. Now, the picture, in this picture, what is pictured is the Holiness Church of God in Jesus' name. People that are part of this religion basically refer to a scripture in the New Testament saying that there are signs of Jesus's followers, and some of the signs is that they'll speak in tongues, but other signs is that they'll take up serpents and that they will drink deadly things and it won't hurt them. So in religious observances, while they are having religious observances, members of this church get bitten by poisonous snakes and drink strychnine poison, to show that they are followers of Jesus because they don't get hurt. Now, sometimes people do get hurt, and this is illegal. It is illegal to do this in your religious observance. Now, I think this particular church is in Tennessee. Um, Again, there was a reality show, and the guy named Jamie Coots they would take the cameras into his church and follow him around, and he was getting bitten by snakes and he was drinking poison. Um, and eventually the show got canceled when Mr. Coots was bitten in a religious ceremony and did not recover. This is illegal. Now, in Tennessee, they said that what they were trying to avoid, their compelling reason for saying that it's illegal to handle snakes in your religious ceremony, is because they want to avoid the unnecessary creation of widows and orphans. That has stood, but usually in those places where this is on the books as something that is illegal, it is small fines, and in some instances is tolerated. What about members of the Sikh religion? If you are familiar with this very peaceful religion, one of the tenets of the religion is that men do not cut their hair. Their power is in their hair. So under those head wraps is a lot of hair. And so there is no way that they can wear hard hats. And so many times, if there is a way to give an exception to a religious practice, that is the way that the government handles it. They don't change the law, they just say it's okay for you. In this, for years and years and years and years, the Sikh religion they were given exemptions, so they did not have to wear hard hats. on construction sites. So if that was their chosen profession, they did not have to. Now, the safety, OSHA, the Safety Commission, eventually changed the rules and said you're gonna have to figure out. I don't know what happened, but they said you're gonna have to wear hard hats. And I just get so tickled that I have kept this for years. If you look at the inscription underneath the picture, these people are in Canada, so British Columbia. So I should do a better job and see if I can't actually get a picture of some people that were in the United States, since we're talking United States. So let's talk exemptions a little bit. There was a case where a young lady was a member of the Seventh-day Adventist religion. She was working at a job. The job was a Monday through Friday job, and was working fine. And then the company decided that they were going to change their work week from a 5-day-a-week work week to a 6-day-a-week work week. Now, number one, I would have been super upset. But this young lady was more than upset. She was Seventh-day Adventist. The 6th day was Saturday, and that was her Sabbath. Seventh-day Adventists meet for church services on the Sabbath, the truth Sabbath, they will tell you, that is on Saturday. So she was missing work on the Sabbath. And eventually she had so many write-ups that she was fired. And so she went and filed unemployment benefits, and of course was denied unemployment benefits because they said we fired her for cause. She was missing work. And she was saying I was missing work for religious reasons. The court did not end up giving her her job back, but what they did do was allowed her to get unemployment benefits, to qualify for unemployment benefits, because she had an exception for religious reasons that was not causing harm to anyone else. And so she was able to collect unemployment benefits until she could secure another job that did not interfere with her religious observance. So that's the way that they normally do it. This young lady is named Sultana Freeman. Sultana Freeman moved to Florida, and she she went to go get a driver's license photo in Florida. Now, where she'd come from, they had allowed her to take her driver's license picture with full burqa, nothing but eyes showing, hijab, burqa, the whole thing. And so she was looking for the state of Florida to do the same thing. And the state of Florida said no. We have a compelling reason to be able to recognize a person to identify a person on their driver's license, and we cannot allow you to take a picture where we're not able to actually identify you. We have a compelling reason that we need your full face. She said it's a violation of my religion. The only person that can see my face is my husband. And so she filed suit. Now, the case didn't get to the United States Supreme Court. It went to the Florida Supreme Court. But Ms. Freeman lost. The state of Florida was able to show that they had offered her accommodations. They had offered to take her in a room with a female, snap the picture real quickly, so there would be no males that would see her, and she refused. And they were able to show that they had a compelling reason for that decision. So Miss Freeman ended up losing. and because they were able to show a compelling reason. So all of those are freedom of exercise cases. If there's a way to do it, they will give you an exception. If there's no way to do it, then they may restrict your religious practice. And go back to Mr. Smith. Not long after Mr. Smith lost his case, there was a case that went to the Supreme Court about the same thing. And it was some restrictions that were being placed on members of a church that used peyote or used a hallucinogen. It may not have been peyote in their religious activity. Not long after the court case, the Supreme Court, I mean, not Supreme Court, the Congress, United States Congress passed the Religious Freedom Restoration Act, and it was 1993, not 1996. Religious Freedom Restoration Act said that government agencies, departments, or any governmental entity was actually prohibited from passing a rule that would be a burden on a person's religious activity. And so this was based on the ruling of the case where they were challenging exactly what Mr. Smith had sought an exception for. My understanding is that you can get exceptions even in the military now for use of peyote if you can show that it is part of your actual religious practice. So this law was passed, the Religious Freedom Restoration Act of 1993, and it ended up having a tremendous impact on common law. In 2009, the Obama administration passed the Affordable Care Act, and sometimes called Obamacare. And there are lots of provisions to the Affordable Care Act. There's just several different parts of it. But one of the parts that sometimes we don't talk about very often was that a parent can carry their child on their health insurance to age 26 now. It used to be 21 was the cutoff. You also the health care coverage that you get, there were restrictions on the quality of the insurance itself. It had to have certain things. You have to get free annual exams, so your checkup and female wellness and birth control has to be covered with no out-of-pocket required for the individual. So there are lots of parts of the Affordable Care Act. In addition, employers up down to a certain level have to offer insurance to their employees. There has to be some offering of insurance to people that are self-employed or who are working for a very small employer. And they were expanding eligibility for Medicaid to people that made slightly above the poverty level. So they were expanding eligibility for Medicaid. So many parts of that have been stricken down. We don't know what's going to happen. It may all be stricken down, but right after the act was completed, there was a big uproar from the Catholic Church. And the Catholic Church said, we're an employer. Oftentimes we have more than the minimum amount of employees. We are subject to Social Security tax. We pay those in. So we fall into the category of employers that cannot offer insurance that does not offer contraceptives. And the Catholic Church was like, hey, excuse us. Many years we have been in objection to contraceptives, and we don't think that we should have to offer that type of insurance. And the Obama administration wrote an executive order and gave Catholic organizations exemptions. Then along comes Hobby Lobby. Hobby Lobby is not a church. It is a company that has religious, I don't know, owners. If you go in Hobby Lobby, they're gonna play Jesus Keep Me Near the Cross and just as I am, and on a loop. And there's a lot of crosses for sale. So they're closed on Sunday, but it is a company. And so Hobby Lobby came and said, hey, we think that is a violation of our religious freedom. Is definitely a violation of the the Religious Freedom Restoration Act to require us to cover contraceptives, especially the day after pill, which we think is abortion, if we have a religious objection. And I remember when the case went up, and I remember thinking, but you're a company. But the case of Burwell versus Hobby Lobby made it up to the Supreme Court. The Supreme Court applied the Religious Freedom Restoration Act and basically said that since the shareholders of the company are all one family, that we're going to say that this is a closely held corporation and that you're not required to cover contraceptives or have insurance that covers contraceptives for free. So in that instance, and I'll be the first to tell you guys that I cannot stand this case. I cannot stand the corporations or people to argument, or we're going to assign to the company the religious beliefs of the owners because it's small. Because in where I come from, you form a corporation so that you can separate the people from the business for liability reasons. But they won. This is still on the books. More recently, there was a case in Colorado after the Obergefell case that said that no state could prohibit people that were the same gender from marrying. There was a couple that went to a bakery and they were getting ready to get married. This was in Colorado, and the gentleman said he couldn't do it. I can't make a cake for a wedding for a same-sex couple. You can pick anything you want to. This happy birthday is nice, but I cannot make a cake that just goes against my religion. The couple sued, and the case actually made it to the Supreme Court, but they did not say that a business owner could, in any circumstance, reject certain clients for religious reasons based on Religious Freedom Restoration Act or anything else. They basically, in that case, said that there was a Colorado law that said that you had to look at objectively the action and they had not applied it correctly, the Colorado law correctly in Colorado. So they kind of wormed their way out of it. Um, and they do that all the time. There was another instance where somebody complained about the under God and the Pledge of Allegiance, and that was an Establishment Clause case. And when the case got to the Supreme Court, instead of answering the question because they did not want to touch it, they said, "Well, y'all got a divorce, and the dad that sued doesn't have primary custody of the kids, so you don't have the standing to sue. So we still don't have that answer. Um, our money has under we trust in God, or in God we trust on it." So there's all kinds of instances where we see some non-absolutes in law. um, the Burwell versus Hobby Lobby stores and the Religious Freedom Restoration Act, and whether or not they're giving exceptions, and the list of situations that I talked about are all free exercise cases and situations, and all are perfect to be addressed when you were talking about how the free exercise clause establishes separation of church and state, because they give exceptions so that people can practice their religion unless there's a compelling reason not to.